Welcome back to Politics on Your Side. A major ruling this week on a Tampa company's lawsuit that has thrown the state's fledgling medical marijuana industry into a flurry. A three-judge panel in Florida's First District Court of Appeals ruled that the state law regulating marijuana is unconstitutional, failing to adhere to Amendment 2, which voters passed overwhelmingly in 2016. The lawsuit was filed by Tampa company Flora Grown, and it basically argues three main things. First, that the state law forces businesses to be vertically integrated, meaning the business must grow, cultivate, package, market, and sell their own marijuana. Second, that the law effectively created a special class, nurseries that had been in business for at least 30 years, that were the only businesses who could get a license to sell marijuana. And third, that the law illegally capped the number of licensees, thereby limiting competition. In this ruling, the judges basically agreed with Flora Grown, but didn't set a timetable. Here to help me unpack the ruling are the owners of Flora Grown, Joe Redner, Adam Eland, and Jeff Marks. Welcome, guys. Thanks for coming.
Thanks for having us.
Nice to be here.
All right, so let's go through these sort of, not necessarily one by one, but we'll start with the big one because that kind of invalidated everything, right? The vertical integration requirement basically forced businesses to sort of be farm to bowl, right? You know, that the judges said the requirement is you've got to do all of these things in the entire marijuana business, unlike any other business in Florida.
It was worse than that. In Florida, they're vertical siloed companies. So not only do they have to do everything, seed to bowl, like you said, but they have to do it alone. They can't contract with anyone. They can't wholesale between each other.
Right.
They can't work together to build an industry. It's a complete silo. So beyond just vertically integrated, that really created an industry that was broken before it ever got off the ground. And that's what we've seen, you know, in Florida with lack of availability, high prices, and lack of options. I think anybody who is a medical marijuana patient in Florida is familiar with the fact that you get there on Monday, you hope you get something before they sell out, because by the end of the week, forget it.
Currently, there's 14 operating licensed businesses in the state of Florida, but there's really not 14 operating businesses. There's 5 or 6 businesses that got in early and have spread out and are providing all the product to the patients. So the rest of the licenses have been sold.
Those licenses have been selling for tens of millions of dollars, right?
$50 million.
$50 million, and then also, there are no other examples that I can think of where an industry says, okay, where the legislature says there can only be 14 of you. There can only be 14 fast food restaurants in the state of Florida, right? That part doesn't really make sense.
All those things are connected because they created these licenses and they made them basically unlimited. Very few of them unlimited licenses. So they
Meaning you can create as much product as you want.
as much product as you want. You could sell as much, you could produce as much, and they can't control it at all. So they created this system where those licenses are insanely valuable. You go to Colorado or someplace else with a mature medical marijuana market, and a license will go for $1 million or $2 million because they don't have the value. It's a business. It's not a license.
So they now said, okay, this is unconstitutional that you can only that you have to be vertically integrated, but that then sort of blows out this number of licenses, which is an arbitrary number, right? I mean, there's no, you guys can get into the history if you want to, but the 14 just kind of came out of nowhere.
I think the story around the legislature is that's the number that the legislature could agree on. It wasn't based on evidence. It wasn't based on a report produced by the Office of Medical Marijuana Use. It was just a number that sounded safe to everybody.
In fact, their reports said they should have a whole bunch more. I don't remember just exactly how much. Adam might.
I think it was around 400 MMTCs, which are what we call our medical marijuana treatment centers, for 100,000 patients. And we currently have about 230,000 patients.
400 per 100,000 patients?
Yeah, that's what that
was
study
their own
said.
information.
So that was based on Colorado.
When the amendment was approved, the Department of Health did a constitutional analysis of how many MMTCs there should be, and they basically came up with about 400 MMTCs for every 100,000 patients. That's something we discovered in our case.
Wow.
Yeah. And really what we found out in our case, we thought this was all the Department of Health, and the Department of Health was pushing, but as we went through discovery and we learned about what was going on, we found that no, they were being put in a very tough position by the legislature because they wrote a clearly unconstitutional law.
And why would the Republicans in Tallahassee restrict free enterprise?
Well, I was just going to get into that, Joe. It's a great segue because this is, most of these politicians believe that we should have, or say that they believe that you should have competition and that you should have robust capitalism where, you don't like the way one company's doing business, well, then start your own company, right? But that's not what they did here.
Well, sort of the two tiers are we should have robust free enterprise and we should adhere to the plain language of the Constitution. So they limited free enterprise, and the horizontal integration is explicitly called for in the plain language of the amendment. It says that these MMTCs should be able to grow, process, or distribute marijuana, essentially.
And they just wrote in and.
So they literally changed the word or to and in the statute, and the court saw that right away.
Right.
I mean, it's a no-brainer. Some of the other things, you have to look a little deeper, you have to look at the record, but they examined the plain language of the Constitution, and they said this is unconstitutional.
And what they really found was that knocks the whole thing out.
Right.
And they said it right there in the oral argument. One of the judges said, well, these caps don't make any sense if there's no vertical integration. You can't have 14 companies if you have no vertical integration.
Right.
So it really blows everything else out of the water. And then when the caps are gone, the special class is gone because
Right.
they're not limiting it to those people.
So what happens now?
That's a great question. I'll tell you, the way I've been answering this question is this. Whatever happens next, because it's dependent on a lot of people, it comes in the context where that law is unconstitutional. The law that regulates our medical marijuana program is unconstitutional. So whatever happens, happens in that context, and that's good for the citizens of Florida and the patients in the medical marijuana program.
All of these things that the amendment mandates that they do, they have not done because they have spent all their time, effort, and resources to keep this cap on the small number of licenses in place, fighting it in court.
And spent a lot of money doing it at the same time, we should point out. And I was just going to ask you, Joe, because specifically, this is not just a hypothetical conversation. You are a stage 4 lung cancer survivor. How many years has it been now?
8 years.
8 years
Yeah,
you are now.
Only 5% only 4% live after 5 years.
And it's amazing that you have so this is actually harming real Floridians right now.
Yeah, it's killing people. Why do they want people to keep from getting their medicine? It just doesn't make any sense to us.
When we filed this injunction that this ruling affirms, we attached 15 affidavits from patients all over Florida who are suffering under the current system.
There is another way that Joe has argued that you should be able to get medical marijuana. We're going to get into that in just a second. Stay with us. We'll be right back. Welcome back to Politics on Your Side. My guests here, the owners of Flora Grown, Adam Elin, Jeff Marks, and Joe Redner. Now, Joe, you have a homegrown lawsuit against the state that actually suffered a bit of a loss a couple of months ago, but you are now appealing to the U.S. Supreme Court to be able to grow
to the state
Supreme Court to be able to grow your own marijuana.
That's correct.
I want to read now. Basically, your argument is that the medical marijuana amendment should allow you to grow your own marijuana.
It says I can.
And I want to read it right now. The amendment pointed to state law 893.02 for the definition of marijuana, which means, quote, all parts of any plant of the genus cannabis, whether growing or not, the seeds thereof, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of the plant, or its seeds or resin.
Yeah, what's confusing in there?
It is a bunch of...
I can possess a plant growing or not. In fact, it says I can do all kinds of things with a plant growing or not. I can, and the seeds thereof. It says I can deliver them. It says I can use them. I can administer them. It says, and they're all constitutional rights.
And that you believe that what is your expectation of success in that lawsuit?
Well, I have to have an expectation of a good expectation because it's the Constitution. It's the final say-so. Anyway.
And that's really the common thread between, it's one of the common threads between these cases.
Because they are two different cases. We do want to point that out.
Yeah, but there are two different cases, and there's really two common threads. One is, like Joe said, the Constitution. There is an assault on the Constitution that's about 30 years old in this state by the legislature. It happened with the Everglades Amendment. It happened with the Class Size Amendment. It's been battling back and forth with the legislature trying to override constitutional amendments. And
follow
now we're
the will
seeing
of the people.
the will of the
Excuse me.
people.
Yeah.
Secondly, it's really about income inequality and access. Marijuana, cannabis is such a touch point for so many different social, economic, and political issues in our country, from the environment to criminal justice. And if you are in a position like Joe is in, you get a diagnosis of lung cancer, or you have a child who could be benefited from cannabis, and you don't have any money, I can tell you, you're not going to go to one of those MMTCs here in Florida and pay for it. But if you can get a seed and put it in the ground and take care of your family, you're in a totally different situation.
Fascinating.
Same thing with this case. With our case, the competition is about having more competition in the industry, is about access for patients to lower prices and more availability, but also access to the industry for people who have been most affected by the bad things that we've done in the war on drugs. Smaller businesses, minority communities, they can't get any access to this business right now in Florida, and hopefully this ruling will change that.
Gentlemen, thank you so much for joining us.
You're so welcome.
Digging into these issues, we really appreciate it. Obviously, an industry that is still developing, and you guys are right on the forefront, and a Tampa company. So thanks so much for spending time with us.
Thanks for
Thank you
having
very
us.
much.
Absolutely. Adam Elin, Jeff Marks, and Joe Redner joining us here today on Politics on Your Side. We'll be right back.